Brett Hudson.
Thank you, Mr Speaker. It's a privilege to be able to rise in support of the Christian Churches New Zealand Property Trust Board Empowering Board Bill in this, its third reading, and it would appear, sir, with the contributions that have been made across both sides of the House, that this has unanimous support across the House. As another member, Ms Logie, mentioned just a little while ago, it's actually a very good thing to be able to sit in this House and contribute in these debates where we are united and each, as she said, looking to work together to find a solution to what is a real and genuine problem for particular people or groups in New Zealand. In this case, of course, the Christian Churches New Zealand, an association of more than 30 congregations throughout New Zealand, and I would make note of the Tawa Union Parish, a parish in the electorate of Ohariu, who will be affected in a positive way when, with the confidence I have, and I think we all share, that this bill is enacted. If we look at the history of this, which I think is really important, when a group of churches come together with a notion to do good across their communities, and inside of any well-forming, particularly a well-functioning democracy, the idea that people or groups will coalesce and provide services and assistance to people in need is something that actually underpins a well-formed, a well-functioning democracy. And we had a case here which dates back, I guess, around 90 years, if we look at the history of this, where these churches saw a need or a desire to do good in their communities, and they coalesced around a notion that if they had, at the time, they were thinking in terms of property, if they had assets, they could put those assets to good purposes to benefit perhaps those who might share similar views, but certainly those who were perhaps a little less fortunate, a little less privileged, or in certain other requirements of need. And if we look back, I think it was in April of 1924 in Dunedin, a conference of these churches came together and said, agreed that they should have trustees of certain members of the churches and that they should form a trust to hold and manage the real estate assets that they would settle and to make sure that they were used for the works they wanted to do. And the reason that had come about, Mr Speaker, was that initially when they had started these works under the use of these assets or this shared approach, they had held the property in the names of the elders of the congregations. And in many respects, you would look at that and say that wasn't perhaps unusual for the nature of church operations of the time, but it actually, I would suggest, the need for change, or the identified need for change in the 20s, was underpinned by a changing society. Because if there's anything, of course, we witness in our own time, but we've witnessed throughout human history, is the evolution of our societal groups and the way they change, the way societies operate, the way they govern themselves, the way that if certain people are going to work together, how you have to do that effectively to deliver the outcomes you want in a way that can be adequately managed. So in 1929, the Associated Churches of Christ Church Property Act was enacted. And that act, that empowered, created the trust that we will in fact be disestablishing with this bill once it's passed, but created the trust that could administer the joint assets, if you will, the assets owned by this congregation of churches, and that could ensure that those assets were put to the use, to the purpose that the congregations, the assembled congregations had. What we, however, see now, just as that act was born of perceived need for change in governance to make sure that at the time there was a better structure for the works the church, the congregations were doing. Now we fast forward, approximately 80 years, a little under 80 years, and we see the same need arise. That if we look at the operations of the congregations today, the way that they might best use the assets they hold and the constraints that the current trust and Empowering Act place upon them, it actually creates a situation where the congregations together might hold sufficient assets to do a great deal of good work across the country, but they can't always use those assets in the way that they feel would provide the best and most good to those in most need. So, for instance, while there is held to be some ambiguity around the language of the empowering legislation as it currently stands, the wording does create doubts as to how the funds held by the board might be applied for the furtherance of the work of the churches. But there is believed to be a strong presumption from that legislation that the funds received are on trust for the purposes of real estate only. And if we consider that, as we have done through the stages of this bill, including a select committee and a committee of the whole House, if we look at that and have canvassed, that actually can, and I think is a perception across those congregations, that it does present constraints on the works that the board and the churches can do for those people that they are looking to serve. And there was a parallel drawn in the committee of the whole stage, I recall, that said that where you hold an asset and you are simply looking to convert that asset, which might be...
I'm sorry to interrupt the honourable member. The time has come for me to leave the chair for the dinner break. This debate is interrupted and I shall resume the chair at 7:30.